Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. Today we would look into how sanctions can affect the contractual relationship between the parties and what the parties can do to mitigate the potential effect of sanctions to the extent their business relates to those areas which have this risk. In particular, we would look into the following points. We would discuss how sanctions can actually affect contracts. These are norms of public law, so to a certain extent it's evident that they would override private law arrangements. But the question is how this actually happens, which laws may be relevant, which laws the parties, which jurisdictions the parties need to consider. Very often sanctions will be coordinated between various jurisdictions. If the sanctions are imposed at the UN level, in principle, they should be imposed by all UN member states. Many of those will have their own sanctions program, and the question is, what specific jurisdictions do you need to take into account for the purpose of your contractual analysis? We will discuss the exact effect which sanctions may have on contracts, and then we would briefly touch upon blocking statutes, non-liability and non-claims clauses in the statutory provisions of various sanctions regime, as well as talk briefly about those mitigants which the parties may wish to take into account when drafting their contracts. So how can sanctions can affect contracts? This in fairness depends on the type of a sanction. Trying to categorize the possible effects, one would talk about three major adverse effects which sanctions may have. The first is that they can prohibit the performance or the execution of new contracts in their entirety. Most of the blocking sanctions will have this effect because most of the blocking sanctions will require that the person who is obliged to comply with those sanctions shall freeze all assets of the blocked person and shall not provide any financial resources, funds, goods, services. The prohibition will be typically framed very broadly. Again, it would depend from jurisdiction as to the exact scope of the prohibition, but the scope will typically be very, very broad in a way that it will affect a standard contract, regardless of whether it's a supply of goods contract, provision of services contract, or some sort of financial arrangement contract. So when the type of sanctions we're talking about are the blocking sanctions, typically it would be impossible to continue the performance of the contract, and it will not be possible to execute new contract unless a special exemption is provided in the regulation or a wind down period for existing contract is provided at the time the sanctions are introduced. The sanctions may not prohibit but restrict the performance of the contracts. This would be typical in case of sectoral sanctions, which would not prohibit the entirety of transactions, but which would restrict the categories of transactions which can be entered into with the sanctioned entities. For example, financial sanctions may restrict access to long-term capital markets, but they will not prohibit short-term borrowings. They will not prohibit discharge of existing contractual obligations under the existing contracts. They may have a broad exemption for existing contracts, so-called grandfathering provisions. There may be quotas imposed in a sense that the sanctions may restrict trade in a certain commodity, but because the commodity is of a particular strategic importance for the exporter countries, they may allow certain minimum amount of commodity which can still be exported. So the bottom line is that in this situation, the entirety of arrangement is affected by the sanctions introduced, but not in a way that it needs to be terminated and no new contracts may be entered into, but in a way that it has to comply with the restrictions which were put in place. Finally, certain obligations may be imposed by sanctions with respect to any types of contracts which have to be observed. For example, reporting obligations. The person subject to the certain sanctions regime may need to report certain type of transactions, which, although not prohibited, are subject to this reporting requirement. There may be certain obligations coming from the regulator whereby certain specific clauses need to be inserted into the contract. For example, clauses prohibiting the re-export of certain sensitive goods to third-party jurisdictions. And there may be other requirements like obtaining authorizations or approvals for the purpose of undertaking certain transactions. It's important to keep in mind that the above restrictions can affect both new contracts, in a sense that a person subject to sanctions is not allowed to execute new transactions, but they may also affect the existing contracts subject to certain grandfathering provisions or exemptions whereby pre-existing contracts relationship may allow to apply for an authorization with the relevant authorities to discharge the contracts. So it should not be taken for granted that sanctions have just prospective effect in the sense that only new relationship is affected. Typically, both would be affected, and it's important to understand to which extent. Then, given the complexity of restrictions we've just discussed, the relationship may be affected in whole or in part. For example, the bank may provide a loan to a borrower and get different type of security with respect to the loan in the form of the guarantees, letters of credit, different types of fixed and floating security. And it may be the case that the entire relationship is affected because, for example, the bank which opened the letter of credit is subject to sanctions, whereas the borrower and the other security providers are not subject to any restrictions and the general relationship is not subject to any restrictions. Here it's important to find that part which is really affected by sanctions and then to carefully read the overall contractual framework to see what are the implications for the general relationship coming from that particular part. Last point to remember is that the sanctions, especially the blocking sanctions in Europe, typically have no wind down and grace periods, in a sense that they have immediate effect with the moment of their publication in the official journal. And in principle, starting from that moment, all assets of the person subject to blocking sanctions have to be blocked, and no new financial resources or funds may be provided to those persons. Which means that it's important to monitor constantly the ongoing sanctions publications with a view to duly discharge your obligations. The approach of the US authorities is different. There, the distinction would typically be between individuals, where blocking sanctions would also enter immediately, and smaller corporations, where the same approach is taken, and bigger corporations with a significant share in the market, where the US authorities would typically provide for so-called wind down licenses, which for a specific period of time allow to wind down transactions. Often those licenses will be subject to various conditions. There will be also a time limit, often quite a short time limit. So whenever the reliance is placed on those licenses, it's very important that their terms are carefully reviewed and you ascertain that that's appropriate for your type of relationship and your type of transaction. To complicate the matters, it's important to keep in mind that various laws in various jurisdictions imposing sanctions may have relevance for your contract. And often it is so, because often, as I already mentioned, the sanctions are introduced on a coordinated level. If they're introduced at the UN level, all member states are obliged to give effect to the UN sanctions regimes in their national legislation. So every member state would have the appropriate restrictions imposed with respect to those transactions or persons which and who are subject to their jurisdictions. With respect to unilateral sanctions or EU type of sanctions, which although may be classified as unilateral, are imposed by a substantial group of states, the efforts would be again quite often coordinated in the sense that the United States would coordinate with European Union as to the relevant sanctions program, and typically the coordination will go on further, including the UK and then Canada, Australia, Japan, Switzerland will typically coordinate their sanctions program with the European Union program, as Norway, for example. So in this sense, it's important to keep in mind that, first of all, various laws can affect the relationship. Certainly, the law governing the contract is important, but it's also important to take into account the law of the courts, which would typically be the same as the law governing the contract, but not necessarily the same. Then it's important to keep in mind the jurisdictions of the location of the persons and the shareholders of those persons, as well as directors and employees, because if the employee holds the nationality of a jurisdiction which imposed sanction, such employee would need to comply with those sanctions in his personal capacity, and that may also have relevance on the capacity of the party to perform the contracts. It's important to take into account the wider contractual relationship or general wider relationship into account. For example, if you have a contract for a sale and purchase of certain commodities, typically this purchase will be financed by third-party banks. There would be insurance companies involved in the insurance of various risks. There would be transportation companies involved. There would be warehouses involved, and many other persons involved, which may be critical for the performance of the contractual relationship. And to the extent any of those persons are located in the jurisdictions imposing the sanctions, it has to be carefully considered what may be the effect of those sanctions for the overall contractual relationship. The origin of goods, in another point taken into account. The origin of goods is relevant because there may be some restrictions on the re-export of those goods to third-party jurisdictions, because the country of origin may impose the sanctions itself. And then the currency of payment, regardless of where the bank of the payer and the payee is located, the international payments are structured in a way that typically the settlement of payments would go through the main financial center, which processes settlements in the relevant currency. So payments in dollars will typically go through the United States. Payments in euros will typically go through the European bank in one form or another. And accordingly, to the extent the payments under the relevant contract are made in the currencies of those jurisdictions, it's important to take into account if any sanctions have been introduced in those jurisdictions, and then to consider the way they affect the relationship. The final point to note is that obviously European sanctions introduced by the European Union in a way of regulations have direct effect in all member states and create rights and obligations of private parties, including affect the contractual relationships of those parties. So from that perspective, it's important to consider that the European Union sanctions have effect to the extent any of the above elements find their place in any of the European member states. So all in all, it's quite a complex analysis to make the initial due diligence, and it's very important to make this initial due diligence to identify those jurisdictions which are relevant for your contract, to keep in mind that there would be typically multiple relevant jurisdictions, and to take into account all elements of the contractual relationship, even which sometimes is not immediately obvious, like, for example, the directors' nationalities, the nationalities of the employees, or various third parties involved in the performance or preparation of the contracts. Once the relevant sanctions regimes have been identified, and once the precise legal rules which set out the sanctions restrictions in those regimes have been identified, it's important then to make the analysis what will be the effect of those rules on your specific relationship, which we briefly set out at the beginning. But what I want to emphasize here is that the relationship will to a very large extent depend on whether the relevant sanctions have been introduced by the jurisdiction governing your contract, governing the law of your contract, or of a third-party jurisdiction. The sanctions introduced by the jurisdiction which law governs your contract will be considered to be part and parcel of the relevant legal order, and they would override the contractual relationship, and the courts of the jurisdiction will not give effect to the provisions of the contract which are inconsistent with the sanctions in one way or another. So from that perspective, to the extent your contract is governed by English law, the sanctions introduced by United Kingdom will have overriding effect over any provisions of the relevant contract. And the same approach would be typically taken to the extent the sanctions which were introduced are the sanctions of the forum of the courts or arbitration tribunals which adjudicate the matter arising under the contract, because the relevant sanctions will normally be considered overriding mandatory principles of law in the jurisdiction of the forum, and then for that reason are highly likely to be given application by the relevant courts in a way that if they restrict the relationship or prohibit the relationship, the relevant provisions will be deemed to be unenforceable. A more complex question is to which extent your contractual relationship is affected by the sanctions of the third-party jurisdictions. And here, I talk more about the effect on the contract itself rather than the effect on the parties of the contract, because it's self-obvious that if a party is located in a third-party jurisdiction, so let's say you have two EU companies which have an English law contract and EU introduces sanctions, then certainly those companies would be obliged to comply with the EU sanctions because that's the personal scope. They would fall within the personal scope of their application. I talk more about the situation when you have, for example, two EU companies which have the English law governed contract, and there are provisions of the third party state, let's say Australia, which restrict the relevant relationship. So the question arises if you then litigate this contract in, for example, the relevant arbitration tribunal. Let's assume for the sake of discussion that the relevant arbitration tribunal is the International Chamber of Commerce in Paris. To which extent it would give the effect to the relevant provisions of the third-party jurisdiction in our example completely unrelated to the relevant contractual relationship. And here, whilst different rules would apply in accordance with the applicable law of the contract, the overriding principle coming from Rome I regulation, which in one form or another finds its roots in national laws of the those countries which subscribe to the regulation, is that the laws of the third parties member states would be relevant to the extent the contract will be performed in that state in one form or another. Performance not necessarily means just the delivery of goods in the relevant state. It can also imply payments. So for example, here we need to take into account the point which we've discussed earlier, that some payments have to pass through their financial center of clearance, and this may inadvertently bring into play the sanctions of the third-party countries, which may not be immediately clear to affect the relevant relationship. So the third-party laws may be relevant for the contract in general to the extent the contract would need to be performed in one form or another in that jurisdiction. Another point to note when we talk about the effect of sanctions on the contractual relationship is the so-called blocking statutes, which have been introduced by various jurisdictions, primarily in response to the US extraterritorial sanctions, meaning those sanctions which purport to regulate relationships which have no effect with the US territory or with the US persons operating abroad. Here I give two examples of the blocking statutes. One is the EU regulation, which was introduced to counter the extraterritorial effect of the US sanctions against Cuba and Iran. And the second one is the UK Statutory Act, which was introduced for the same purpose, the act itself and the relevant order, which I give here as an example, was introduced for the purpose of taking countermeasures against the US sanctions, which purported to restrict the participation of the British subsidiaries of the US companies in the construction of Yamal pipeline. The general purpose of the blocking statutes is to counteract the extraterritorial effect of the sanctions of the other jurisdictions. And in principle, what they would do, as the Section 1.1 and 3 of the Protection of Trading Interest Acts in the UK is doing, is that they would specifically target only those sanctions which have extraterritorial effect, and they would prohibit compliance for certain companies with those sanctions, and then they would have also the exculpatory provisions in a way that they would not carry any responsibility in connection with taking those acts. So that's important to take into account in the context of what we've just discussed, on top of the analysis of what are the sanctions which are relevant. One has also to bring another layer of analysis of discussing and considering any blocking statutes, which may affect the performance of the contract in the relevant jurisdictions where those statutes were imposed. As we can see by now, the contractual analysis of what is the effect of sanctions is very complex. And certainly, this can result in very substantial disputes between the parties to the contract. On the other hand, non-compliance with sanctions and breach of sanctions is typically a criminal offense, has to be, in general terms, a criminal offense in Europe. And in certain jurisdictions like the UK, it's a criminal offense subject to a strict liability concept, meaning that it doesn't matter what measures have been taken by the relevant operators. It doesn't matter what was their state of mind. To the extent there is a factual breach of sanction, the relevant operator is criminally liable. So there are very substantial penalties which may potentially affect operators for sanctions in compliance. If we weigh this against all the complexities which we've discussed, that puts the operators in a very difficult situation with respect to their counterparts. The regulators seem to acknowledge those problems by introducing so-called non-liability, non-claims provisions in the statutory laws, introducing the sanctions regimes. And in essence, the purpose of those provisions is to ensure that, to extent the relevant operator acted in good faith, with relevant diligence, not with a view to damage the counterparty, to escape his contractual relationship, to the extent he did not perform the contract in accordance with its terms in reliance on the relevant restrictions, the operator shall not be liable for any breach of contract resulting from that restriction, and the relevant operator shall also not be subject to any claims. It would be, although the relevant provisions are drafted typically in very broad terms, certainly, as with any other non-liability, non-claims provision, the relevant laws have to be consulted very diligently. So, for example, in the European Union, the non-liability provision, by way of example, applies only to the situation of the blocking sanctions, restrictions, and those contractual non-performance, which were the result of the blocking sanction restrictions. Which means that with respect to the sectoral sanctions, no similar protection is accorded to the parties. Same story with the non-claims. If we read carefully the relevant clause, which is a standard clause, meaning that every EU sanctions regulation uses the clause fundamentally drafted in the same way, we can see that it protects just against the claims of the parties who are listed in the regulation or of those parties who act on their behalf. And then the question arises, what will happen in a situation if the original listed party lawfully assigned its claim to a non-listed party within its regulation, to an independent party, which is not acting on behalf of the original listed party? Technically speaking, if this new assignee brings a claim against the original party to the contract, this party will neither be listed nor acted on behalf of the listed party. And the question arises whether the courts will give a broader interpretation to the relevant clause and would still allow the protections coming from the clause. So in essence, like with any other exculpatory provision, great care needs to be taken as to the analysis of the exact scope of the clause and of its applicability to your specific situation. Taking the complexity of all those issues in mind, especially for those contracts which are long-term, complex contractual relationships, like, for example, long-term loan agreements or very complex construction projects, project finance construction projects, which may last for many years. Certainly, the parties tend not to rely on the general provisions of law and aim to try to foresee, to the extent relevant, the various sanctions regimes which may, in the course of their performance of the long-term contract, affect this relationship, and draft the so-called sanctions or force majeure clauses, which would include sanctions as a subcategory of force majeure, with a view to make the wind down of their relationship as predictable as possible and ensure that it's done at least in an orderly manner. So the sanction clauses are more and more common today, and they would typically address the points which I list on the slides. They would first of all address the matter of who and how decides that the relevant trigger event occurs. Is it something to be objective, subjective? If subjective, meaning that one of the parties shall have discretion to trigger the relevant event, what kind of precautionary measures would be set out in the contract to ensure that this party is not unreasonably and overcautiously, in the circumstance when it's convenient for that party, declares an event a sanctions event. There would be time frames set out how those provisions shall operate, as well as the legal effect of the termination, whether the contract will be terminated immediately upon the delivery of the notice, where a certain grace period will be provided, how long that grace period would be, what will be the liability of the parties, will the contract be terminated in whole or in part. An important point which would be always addressed is the responsibility of those parties to take mitigating steps to the extent possible, namely to seek authorizations in the relevant jurisdictions if they are available to continue with the performance of the contract or the winding down of the contract. And then there would be different rules with respect to the specific elements of the contract which may be affected by the sanctions. For example, currency will be the most typical point to think about, in a sense that the only element which is affected by the sanctions is currency. Then the parties would typically wish to set out so-called alternative currency provisions, which allow in those circumstances to perform the obligations in the alternative currencies. It's important to keep in mind that although useful and typically included in the contracts today, these clauses have ultimately limited value, especially if the sanctions affect the jurisdiction of incorporation of the parties or the jurisdictions where the relevant goods are of origin. It's also important to draft those clauses carefully with a view to avoid of being incurring the risk that these are terms to circumvent the subsequent restrictions. So the clauses need to be drafted in a way that they take care of the genuine interests of the parties to ensure orderly wind down within those legal provisions which typically would not be affected by the sanctions of the relevant jurisdictions. I hope that you find this presentation useful and a good starting point to think of how sanctions may affect your contractual relationship. Thank you very much for watching.